Good afternoon, and thank you for attending the webinar, Background Screening 101. This is Cindy Hansen, and with me I have Meg Nichols. We are both with Troutman Sanders, and we're really happy to present this webinar today, which is really meant to be an overview of issues under the Fair Credit Reporting Act as they relate to the use of background checks in the employment process, and what are the requirements that a user must follow under the Fair Credit Reporting Act. With that, Meg, why don't you get us started with your portion?
Sure, thanks Cindy, and thanks everyone for joining. So I'm just going to start with a general overview of the FCRA and the purposes set forth in Section 602 by Congress. The underlying assumption that we see throughout the FCRA is that Congress wanted to recognize that inaccurate consumer reporting information undermines public confidence. It was originally geared towards the banking system, but has since broadened to include more than that. But the FCRA was enacted to help kind of prevent that inaccurate information and to promote fair and accurate credit and other types of consumer reporting. Consumer reporting agencies are recognized by Congress as providing a vital role in assembling and evaluating consumer credit and any other information on consumers that's included in a consumer report. And to broadly effectuate this purpose, the FCRA requires that CRAs adopt reasonable procedures for meeting the needs of commerce in a manner that is fair and equitable to the consumer. Next slide. So we kind of get right into the definition of consumer report here. There are three main elements. It's a communication of information from a consumer reporting agency. A consumer reporting agency like Checkr. The consumer report is used to determine a consumer's eligibility, and there's 7 factors that are really important to look at when you're looking at a consumer report. Consumer report bears on a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, personal characteristics, or mode of living. An investigative consumer report is actually a specific type of consumer report that deals with a subset of the 7 factors. Usually it's information on a consumer's character, general reputation, personal characteristics, or mode of living. Notice credit is missing from this. It's not usually a credit report in the traditional sense. And the primary element of an investigative consumer report is that it's obtained through personal interviews. Usually these interviews are conducted with neighbors or friends or basically anyone who's acquainted with the consumer who would have some personal knowledge of that consumer's behaviors or characteristics. Next slide. So I mentioned that Checkr is a consumer reporting agency, but under the FCRA it's broadly defined as any person, and a person is defined in the FCRA as an entity. Which for monetary fees, dues, or on a non-cooperative nonprofit, on a cooperative nonprofit basis, regularly engages in whole or in part in the practice of assembling or evaluating consumer information, and this assembling or evaluating is done for the purpose of furnishing consumer reports to third parties. Consumer reporting agency will use a means or facility of interstate commerce to furnish the consumer report to end users. Next slide. And so we kind of look at what is an end user under the FCRA. Broadly, it's the final person that receives the information or the consumer report, and it's usually the one who actually uses the information within the consumer report to determine the consumer's eligibility. An employer is an example of an end user if they order a consumer report for the purpose of evaluating a consumer for employment, promotion, reassignment, or retention as an employee. So a lot of employers that order consumer reports are considered end users under the FCRA, and as Cindy mentioned, there are specific provisions that are required to be complied with under the FCRA for that purpose. An employee, it's important to kind of look at the definition of who is an employee. It's not just the traditional staff member that you would think as an employee of your agency or your company, but it's defined more broadly under the FCRA. The FTC has taken the interpretation that it's an independent contractor, it could be a volunteer or an agent as well. I'll turn it over to Cindy for more information.
Thank you, Meg. So as we've said, if you are an end user and you are going to be using a consumer report for employment purposes, you have specific obligations under the FCRA that do not apply in other contexts. So as is well known, most employers, in fact, just about all employers, obtain criminal background checks and other sorts of background checks from companies such as Checkr to review the people they are looking at hiring, applicants, or at their current employees at different points in their employment process. So those background checks are consumer reports under the FCRA, assuming they're provided by a consumer reporting agency. And so as an end user in that context, you now have certain obligations that you must fulfill both before and after you obtain that background check. So before you actually obtain the consumer report from a consumer reporting agency, you must give the consumer, be it the applicant or your existing employee, a disclosure of the fact that you intend to obtain a consumer report for employment purposes. I do a lot of work in the FCRA. It is not a very crystal clear statute in many regards, but on this point, the FCRA is pretty clear in that this disclosure must be in a document consisting solely of the disclosure. So you cannot put the disclosure in a document or on a piece of paper that has a bunch of other information on it. Essentially, it cannot be buried. So, for example, you cannot have the disclosure cannot have a waiver of liability in it. It cannot say anything about the application effectiveness period. It cannot say anything, it cannot have any kind of disclaimer trying to disclaim the accuracy of the background check or of the search that's going to be run. It can't have any other information about the nature and scope of the investigation. Very recently, the FTC has issued, not formal guidance, but they did put something out on their blog that went over this point, and somebody once said, keep it simple, stupid, and that's really what this comes down to. This should really be a very simple document, have a couple of sentences and nothing else. It should have far more white space than it has text. This, as you will see later on, the FCRA does have some significant liability provisions. This has been an enormous generator of liability in terms of attorneys trying to find anything else in your disclosure document as a hook in which to sue employers on. So really, really important that this disclosure be in a document that has nothing else on it. If you're doing your application process on a electronic platform through a kiosk or through the web, your disclosure should be on a screen that consists solely of that disclosure. So really, really important point. I really can't emphasize it enough. If you are going to, Meg talked about a second type of consumer reporting, an investigative consumer report. And if you are going to get that type of report on a consumer, on an applicant, you have to give a separate disclosure disclosing the fact that you're going to get an investigative consumer report. That disclosure must be clear and accurate, and it provides the applicant with information, with the notice, the fact that you're going to get an investigative consumer report. It must contain a little bit of information as to what an investigative consumer report is, that it's going to be information on a consumer's character, general reputation, personal characteristics, or mode of living. And that disclosure must also advise the consumer that they have the right to request a disclosure, or they have a right to request additional information about the nature and scope of the investigation that's been requested. Again, this disclosure, best practice, should be separate and apart from the first disclosure that I talked about. So you have a disclosure given for just the general basic consumer report, and then this second disclosure is given when you're, if and only if you're going to obtain an investigative consumer report on a applicant or employee. The next thing that you must do, again, prior to obtaining a consumer report, so you've given disclosures, you now must obtain the consumer's applicant or employee, whichever is relevant. You must obtain their written authorization. So you have to obtain from them authorization in order to run this consumer report. The FCRA says that the authorization must be in writing, but it can be done electronically as long as you meet the state and federal requirements of e-sign and similar type laws, as long as you give the proper disclosures that you're going to request something electronically that the consumer has the right to receive in writing. You can obtain this electronically. Another thing that you have to do as an end user in an employment context is you have to give a certification back to the consumer reporting agency. So you as the end user have to certify several things to the consumer reporting agency. First, you have to certify that you've given the consumer a disclosure. Second, you have to certify to the consumer reporting agency that you have obtained the consumer's authorization. Next, you have to certify that you will not use the consumer report in violation of federal or state equal opportunity laws or regulations. Basically, you're not going to use the consumer report in some discriminatory manner. And last, you certify that if, as a result of this consumer report, you may take some adverse action, that you are going to comply with the FCRA's rules regarding adverse action. So let's turn to that. So now we're at the point, we've given disclosures, we've received authorizations, we've made our certifications to the consumer reporting agency. You get this consumer report now in your hand. First thing we need to understand is, what is adverse action? Think of adverse action as very broadly. Obviously, it is the denial of an employment. So if you're going to deny an applicant a job, that's adverse action. But it also includes any decision that adversely affects a current or prospective employee. So if you have an applicant and they've applied for a certain job, and as a result of the background check, you feel you have to offer them a different job or a lesser job, that would be adverse action. If you have an employee that you are thinking about promoting and you decide not to give them the promotion, that would be adverse action. It can be as broad as, even if you're going to do a lateral move of an employee, and because of something in their consumer reports, you decide they can't make that lateral move, or they can't change locations, they can't relocate, or you decide you're going to demote them. Anything that would adversely affect that employee, that's all under the rubric of adverse action. So think about this on a very broad basis. So you now have this consumer report in hand, and you decide, there's something on this consumer report, I might take adverse action. Stop. You must give something called pre-adverse action notice, and it's pre because must be taken before you take any adverse action. So before you pick up the phone and call the employee or the applicant and you say, I'm sorry, I can't hire you because of something in this report, or you tell the employee, I'm sorry, you can't get this promotion, what you must first do is give pre-adverse action notice. What that notice consists of is, it's typically a cover letter that says, enclosed is a consumer report that may impact our decision. That your notice should not say, because of the report attached, we've decided not to hire you. It must be in terms of, here is a consumer report that we are considering along with your application. So it's stated in very generic terms and does not in any way suggest that you have decided to take adverse action. So you send that sort of cover letter. It must include a copy of the consumer report that are potentially impacting your decision. It must include a copy of the summary of rights that is created by the CFPB. And this also obviously all should be in writing. You send that to the employee or the applicant. You can send it via regular mail. You can also email it, assuming you have a secure way to email it. It's becoming more and more commonplace to actually do this electronically. The benefit of electronically is it's going to get to the consumer, in theory, instantaneously, whereas if you put it in the mail, it's going to take a couple of days for it to reach the applicant. Once you send this notice, you have to wait, because the idea is, the purpose of this notice is to give the employee or the applicant a chance to see the consumer report and to react to it if they feel that they need to. So you, as the employer, now have to wait a, quote, reasonable amount of time. The problem is no one has defined a reasonable amount of time. The FTC a while ago said at least 5 days. I would view that as 5 business days. That's a relatively short amount of time if you're going to put one of these in the mail. So a better practice is probably longer than 5 days. The purpose of this waiting period is obviously to give the consumer the opportunity to get the report, review it, to maybe come to the employer and explain, look, let me explain to you about this criminal record, or let me give you some context. Don't make a decision just based upon this record with no context. And next, it's also to give the consumer the ability to dispute the information if they feel it is somehow inaccurate or incomplete. So it gives the consumer the ability to at least be able to tell their side of the story, if you will, before a decision is ultimately made. If you are an employer and you send out this notice and the applicant comes to you and tells you, yes, this is my record, but let me give you some context, you should consider that context when you're making your decision. You don't have to, just because they gave you some explanation, have to hire that person, but you should consider what the applicant told you. Alternatively, if you as the employer learn that the applicant in this sort of waiting period did file a dispute with the consumer reporting agency, that perhaps something was either inaccurate or incomplete, you should wait for that. The best practice is to wait for that dispute to complete before you make a decision. Because if there was something inaccurate, it's obviously to everyone's benefit that you be making a decision off accurate information. So you should consider information you receive from the consumer. You should wait if there is a dispute. Let's assume we get to the point either you don't hear from the consumer and there was no dispute, or there was a dispute but it was decided that the information is accurate. So you've been through this waiting period and you decide, no, I can't hire this person because of this report, or I can't promote this person. Then what do? You are now at a point where you can take adverse action. You can take that step. But in taking that adverse action step, you now must provide a second notice. So there are 2 separate and distinct notices. The second notice, frequently called the adverse action notice, again, in writing, and this contains a lot of the same information that was in the first report, or in the first notice, but you still must provide it. So this notice must say, we are taking this action on the basis, or at least in whole or in part, on the consumer report. So you're advising the consumer that the consumer report played a role in your decision. You must give the name, address, and telephone number of the consumer reporting agency that provided the report. You must specifically state that the consumer reporting agency did not make the hiring decision, and they can't give any specific reasons for why that decision was made. They merely produced the report. And you also must tell the consumer that they have the right to dispute the accuracy or completeness of the information in the report, and to get a free report in the next 60 days if they would like. Again, it's somewhat duplicative of what's in the first notice, but it is a 2-step process. Both notices are required. And that sort of brings to an end of what your requirements are as an employer in this context. A couple other things to just quickly go through. Disposal rules. There are some specific regulations on how you dispose of consumer reports or any information from a consumer report. This is obviously highly sensitive, private information of a consumer, frequently contains social security numbers, dates of birth, you know, facts about people. If it's credit, that's clearly private information. Even criminal information, though derived from a public record, it's not something that anybody wants to have disseminated, you know, in a wide way. So there are some specific disposal rules. Consumer reports should be kept under lock and key. If you do dispose them, they should be shredded or burned or pulverized. Just don't throw them out in the general trash bin where anybody can pick them up. And if they are kept in electronic format, then obviously they are kept in a secure way. One question we get a lot is how long should you maintain these sort of disclosures and authorizations and the consumer reports? Our recommendation at a minimum is 2 years and 6 months. I say that because the FCRA has a statute of limitations. It's a 2-year statute of limitations, but it essentially has a 5-year statute of repose, which means you can bring a lawsuit for 2 years after you discover the violation up until 5 years after the violation occurred. At a minimum, you should keep all this information for 2 years and 6 months. I add the 6 months to the 2 years to allow if a suit is filed, you don't always get notice of it immediately. Some people keep it for that whole 5-year period. So that's something to be considered, but important when you are disposing that you do so in a manner of the way the FTC is required. So I guess the next question is why is all of, I'm sorry, go ahead, Meg.
Sorry, if I could just jump in for 1 second. So the other important piece on retention is just to make sure that you're looking at the agreement that you have with whatever consumer reporting agency that you're obtaining the reports from. Sometimes they will include a specific retention requirement. That's a contractual, usually, retention requirement outside of the FCRA, but just kind of a note to check that.
Yeah, absolutely. Great point. So as an end user, why do I care about all this? One, you obviously want to comply with the law, but two, the FCRA has some really onerous liability provisions. The failure to provide the disclosure, to obtain the authorization, or to give that pre-adverse action notice is a violation of the statute, can subject you to civil liability. The FCRA has sort of a two-tier liability scenario. If you are found negligently non-compliant with the FCRA, a consumer can recover actual damages and attorney's fees. So even, you know, negligent violation, single plaintiff case, but if you, let's say the report was inaccurate, but you didn't give the consumer notice, then the consumer might be able to say, hey, had you given me notice of this, I would have been able to show you it was inaccurate. I would have gotten that job. In the meantime, I didn't get another job for 6 months, and I want my lost wages. I want my emotional distress. So, you know, even negligent, single plaintiff negligent cases, there have been verdicts in, you know, $50, $100, $200, $300,000. So these are not super low, these are not low dollar cases. The scarier part of the FCRA, though, is the next provision. If your violation is found to be willful, which meant you knowingly disregarded the FCRA or you recklessly disregarded the FCRA, a consumer can recover statutory damages of between $100 to $1,000 per violation. Doesn't sound like a lot of money. Fine, I pay somebody $1,000. The issue becomes class actions. If you are using a disclosure that is not compliant, and you give that disclosure out 1,000 times in a year, that's 1,000 times 1,000. And the math becomes very scary very quickly. And so the real liability risk in the FCRA are class actions. Some of the requirements that I went over are very, you know, it's a process. So if your process isn't set correctly, you probably made the same mistake over and over and over again. And so really important to get these things correct. There has been a lot of litigation under the FCRA for years. The litigation against employers for not following these steps has really probably started about 5 or 6 years ago. And every single year, more cases get filed. A lot of plaintiffs, attorneys out there looking to bring these cases. And and they get brought, they get settled. There have been many settlements. There have been many multi-million-dollar settlements. So it doesn't sound difficult, but really important that you get all of this correct. Meg, why don't you wrap us up with best practices?
Sure. So looking from a compliance perspective, what are some things that you could do to help ensure that you're maintaining your responsibilities under the FCRA? So we can suggest that you have policies and procedures in place for particular provisions under the FCRA, and specifically a couple of the pieces that we've covered today, such as that you only order consumer reports when you have a permissible purpose to do so. So looking at your policies and procedures, sometimes it's a best practice to include a specific prohibition against ordering a consumer report from a consumer reporting agency for mere curiosity's sake, or prohibiting your employees from ordering consumer reports on themselves, for example. But there needs to be a permissible purpose, and your policies and procedures should designate when that permissible purpose is. Permissible purpose, disclosure given, and proper authorization obtained should be something that is contemplated by your policies and your procedures. So prior to ordering that consumer report, you want to make sure that you've taken the steps as required by the FCRA, you've given disclosure, you've obtained the proper authorization. Once you receive the consumer report, then your policies and procedures should dictate what you do with that consumer report and how you handle pre-adverse action and adverse action notice requirements if those come into play. The other important best practice when you're looking at a consumer report is how you're going to secure that consumer report and how you're going to destroy it. Sometimes you may include retention requirements in like a document retention policy, and then you'll separately, you may address consumer report storage or confidential information storage and proper destruction of that information according to your retention policies.
And with that, I don't know if we have any questions. Okay, let me see. We have one here. Which is, I'm sorry, I just lost it. If I am an employer that runs my own background checks to pre-employment screening, what are my legal obligations under the FCRA? If you are an employer and you are truly running your own, you are checking public records, then you don't have any obligations under the FCRA. The FCRA applies when you obtain a consumer report, and a consumer report is information received from a consumer reporting agency. I would just caution that even if you think you are obtaining information not from a consumer reporting agency, definitions of consumer reporting agency are very broad, and so you really need to understand where you're gathering your information from before you make the decision that you do not have legal obligations under the FCRA. Meg, I don't know if you have anything to add to that.
No, I would just seriously, just as you caution, just make sure that it's not from a consumer reporting agency and that there's no other issues with obtaining that data.
A second question is, can I tell potential employees in the consumer report disclosure that they cannot sue me because I made a decision not to hire them based upon their criminal background check? No. That disclosure that is given to the consumer before you ever get the consumer report cannot have a waiver of liability. That has been the subject of significant litigation, and even at the sort of appellate court, higher court level. So do not include a waiver of liability or any other sort of language that tries to limit liability in that disclosure. That disclosure needs to be a very clean, simple disclosure only form. Meg, one for you on destroying documents, how long do I need to keep the consumer reports before I destroy them?
So I think, as we discussed, there's a couple of elements that you want to look at here. First, liability under FCRA, as Cindy discussed, you want to do 2 years, 6 months, 5 years, case of a longer retention period. So you have the FCRA requirements. Another element to look at is your contract with the consumer reporting agency. And then the third piece that you want to ensure that you've just buttoned everything up is your document retention policy and ensuring that you're abiding by your internal requirements as well.
Okay, great. Well, thank you everyone for joining us. I want to keep to our 30 minutes. I hope that this has been informative for everyone on the phone, and appreciate everyone attending. Thank you.